Okay, let's start again. Hello and welcome, everyone. My name is Sapira Churk. I am the Artist Service Specialist from the Nevada Arts Council. And a little bit before we start, if you have any questions, you can utilize the raise hands function or chat it in the Q&A box so we can answer that. And Kara will be able to manage the Q&A, or I can assist if you like. We can either hold the questions to the end, or you can write them in as those questions comes up. And yeah, and if you would like, we have been doing a little bit of introductions in the chat. You are welcome to share with us your name, where you're calling in from, and a little bit more about your art practice. So we're very, very excited today. I am joined by Kara Erdman from the Artist Rights Society to talk about copyrights, intellectual property, and licensing for visual artists. These are all topics artists often don't think about until they are presented with a contract, and navigating a legal document can be daunting. So for this workshop, we hope that the artists will have a basic understanding of the law that protects their work. We're excited to introduce Kara. Kara is the licensing executive and manager of membership services at Artist Rights Society, where she works with artists to demystify the world of copyright and handle licensing deals in a number of industries, including consumer products, fashion and apparel, museum and education, and more. Previously, she worked in development at CUE Art Foundation, supporting their programs for emerging and under-recognized artists in New York City. She holds a Bachelor of Art in Art History from Barnard College. Welcome.
Thank you so much, Sapira. It's so great to be here, and it's nice to see people are coming from all over the country, which is really cool. We have a great little group. I'm just going to share screen so I can get some slides up and get started because we have lots to talk about in just an hour. So like Sapira said, I'm going to just be talking a little bit about kind of the basics of artist rights. And if you are an artist or an arts professional who kind of knows nothing about copyright, you are truly not alone, because my role at Artist Rights Society is really working directly with our members, onboarding them and kind of helping them navigate tough copyright situations. And even those artists who have had access to, the most prestigious MFA programs or other types of, institutional trainings, you know, not it's not a prerequisite for being a successful artist that your ABCs of copyright. So I'm here to kind of start at square one and talk about kind of just really key concepts that hopefully will help you be able to navigate situations in the future and feel like you have a little bit more autonomy when it comes to making decisions about how you want your work to be reproduced. So I'll go ahead and get started. Just to give you an overview of what we'll be covering, I'll talk a little bit about ARS and our position in the ecosystem, and then some stuff about copyright, licensing, and reprography, resale, and other types of cool, interesting artist rights that maybe aren't protected yet in the US, but hopefully will be soon. So I'll talk just a bit about ARS so you kind of understand where our role is and kind of what our position is in this world of artist rights. We are a licensing agency for visual artists. We work with over 100,000 artists worldwide because we're part of a network of copyright management organizations under a consortium called CSAC, which includes organizations like ASCAP and BMI that represent composers and lyricists and singers and playwrights and screenwriters, all types of authors who produce copyrighted material. And what we do is we act as the agent for our visual artist members' rights of reproduction for their intellectual property interests. So what that looks like is when folks want to reproduce a work by one of our artists in a textbook, or as set dressing for a film and television production, or on a t-shirt, they come to us and we, as their agent, basically manage that negotiation on their behalf. We make sure the artist is justly compensated for the use of their work, and we make sure that they feel comfortable with the way that their work is being shown. And we work in all different types of industries. This is just like a little, some kind of highlighted, maybe more high profile projects that we've worked on recently. Like I said, anywhere that an artwork can be reproduced, you can license it. We've licensed it, from book covers, luxury goods, Broadway shows, exhibition catalogs, film and TV set dressing. There's all different ways that artists' works are used and are consumed by other folks outside of the context of like a museum or a gallery. And so our position and our job is just to make sure that artists know where their work is being used and that they feel happy about the way that their work is being used. And with that, I'll dive a little bit into Copyright 101. I will sort of give a disclaimer by saying that we have attorneys on staff. I am not an attorney. I work with artists, so none of this is, of course, like legal advice. If you have I'm not in a position to give legal advice, obviously, but this is just information that hopefully will help you to feel like you have more knowledge about what is copyright and what are artist rights. So we'll go ahead and dive in. Copyright is a type of intellectual property that protects original works of authorship as soon as the author fixes the work in a tangible form of expression. That's the definition that we have from the US Copyright Office. So copyright is, unlike, patents or trademarks, copyright pertains to creative works that are being produced by visual artists, by musicians, by authors, et cetera, et cetera. And what is amazing is under US copyright law and for many other countries, as soon as you create a work and you fix it in a tangible form, it's copyright protected. You don't need to do anything else. You don't even need to register it with the US Copyright Office. As soon as you create it, you own the copyright to that work unless you transfer the rights to someone else in writing. So those stay with you. And that is true regardless of the ownership or the location of the physical work of art to which that rights pertain. So for example, if you sell a work, or if a work is acquired by a museum, or if, God forbid, a work of yours is destroyed, you're still the holder of those intellectual property rights. You still own the copyright to that work unless you're transferring the rights to someone else in writing. And at least in the US, within most sales that your dealer might be negotiating, or most loans or acquisitions by institutions, it would be very rare for the copyright to travel with the artwork. It doesn't travel unless you explicitly specify that it does. So you can kind of rest at ease knowing if you're someone who's producing work, you own the copyright to those works. One sort of, with every rule, especially in copyright, there is an exception. There is kind of one notable exception to this, which is if you're working under work for hire agreements, meaning if you are, for example, a commercial illustrator, or if you're a photographer who is being commissioned by, say, a magazine to do a photo shoot. There might be something in the terms of your agreement with your employer who you're producing work for that your employer might retain the rights to those works. So just always read your contracts, make sure you understand who the rights holder is, what rights you have. But unless that's specifically, explicitly said in your agreement with them, you are the rights holder. If you walk away with anything today, I have this big little banner. Once it's created, it's copyrighted. I'm going to sound like a broken record saying this, as is everyone at our office, because it's such a misconception that you have to do something else. You have to take additional steps to have your works protected. You don't. Once it's created, it's copyrighted. You have all the protections under the US Copyright Act. So you can rest at ease and hopefully take a little bit of like a burden off your shoulders with that. So what works are copyrightable? There's basically three kind of tenets that a work needs to fulfill to be eligible for copyright protection in the US. It has, and this seems kind of, pretty intuitive. It has to be a work of human authorship. And obviously sort of the question here that's, a lot of people are thinking about is, well, how does AI play into this? And without sort of going off on too much of a tangent, there's obviously a lot of court cases happening surrounding, copyright protection for AI generated works. Our directive that we've received at this time from the US Copyright Office is that human authorship is a requisite for copyright protection, and that works that involve the use of AI may be partially protected as far as the human contributions to that work go. Works must be fixed in a tangible medium of expression. What this means is that copyright does not protect ideas, concepts, methods, or styles. It has to be fixed in a perceivable way where there's definitive elements that are not transient and that are tangible to the outside world. And obviously the work has to be original. That seems kind of like a no-brainer. It can't be a copy. So with those three things in mind, once you create a work, it's copyrighted. And with that copyright protection comes basically the right to decide how the work is going to be used and whether you want to grant permission to other parties to be able to reproduce the work. And if so, under what terms and under what conditions are you comfortable with them reproducing the work? And do you want to charge them a fee in order for them to be able to reproduce the work? For example, if it's maybe a commercial use or something. So how do artists manage copyright? Like we said, once you're the author of a work, once you create it, it's copyrighted unless you're transferring it in writing to another party. Now, something to think about if you're an artist who is maybe starting to look at succession, estate, and legacy planning is that copyright is protected after you pass away. So eventually that copyright is going to be managed by another party, whatever party receives the rights, maybe in your will or other estate planning documents that you're preparing. So artists can bequeath the exclusive rights of their works or a group of work to other parties in writing via a will, via other paperwork, if you want to hand over basically all control over how that work is being reproduced to someone else. And obviously, being an artist is a lot of work, and having intensive knowledge about the field of licensing and kind of the legal nuances of contracts is a huge expectation to have. So many artists do authorize agents to represent them in represent their licensing interests. So that's basically what we do. We're the authorized licensor of our artist members, but artists might authorize their gallery, or they might authorize their business manager, or maybe they just have a friend who they want to manage their copyright interests on their behalf. So there's lots of different ways, every artist kind of might have their own system that they develop that works for them for handling image permissions requests that they get. Copyright term. So copyright term refers to how long copyright protection is afforded to a particular work. In the US, for works published after 1978, the copyright term is life of the artist plus 70 years. For works published before 1978, there's some exceptions, and works might be protected for a different period of time. But if you're producing work right now, you can assume that those works are protected 70 years after you pass away. And something to note is obviously, with all of these kind of details, it differs in the legislation country to country. So in the US, copyright term is life of the artist plus 70 years. In many countries around the world, it's the same, but not in all. I do have this map of the Berne Convention signatories. And like I said, not to go off on another tangent, but this is basically folks who have signed on to the Berne Convention, which was back in the 19th century, like a convention to decide on the rights of artists. So most of these countries that are highlighted in blue have a copyright term that's pretty comparable. In some countries, it's even longer. It's like in Mexico, it's the life of the artist plus 100 years. So there really is a significant period of time after artists pass away that their rights are still protected, and that you can still, your heirs or the future party managing your rights can really take advantage and navigate that realm of licensing after artists are no longer here. And just also something to note that in terms of kind of US Copyright Office definitions, publication is not the same as a work being created. There's a differentiation between the year a work is created and the year when it was first literally published, as in like published in a book or otherwise kind of made available to public in that way. So I put in these little quizzes, but I know it's a small group, so if folks are feeling self-conscious about trying to put a guess in the chat, no worries. But if you want to go ahead and try to put in an answer for when is a work protected, we have A, 70 years after the death of the artist, B, depends on when it was first published, C, depends on the country, and D, all of the above. And like I said, no hard feelings if you get something wrong, because before I started working at Artists' Rights Society, I truly knew next to nothing about copyright. So this is something, like I said, it's not common knowledge. Okay, D. Exactly, all of the above, which I think is what most folks said. So you have to look at a number of different factors. What country are you in? When was the work first published? Has it been 70 years after the death of the artist? There's lots of different factors that you need to look at to determine whether a work is protected. And like I said, with every rule, there comes an exception, public domain. And this is probably a term that maybe you've heard before and is definitely a term that carries a lot of misconceptions with it. The public domain essentially refers, if you say a work is in the public domain, it means that work is not copyright protected, either because the copyright term has expired, so maybe it's been 70 years, more than 70 years after the death of the artist, or maybe it was never under copyright protection to begin with. So think about like the Mona Lisa. Obviously, we can reasonably assume that Leonardo da Vinci died more than 70 years ago. Therefore, the Mona Lisa is in the public domain. In very, very rare cases, an artist can waive or forfeit their rights. This is really, really incredibly anomalous for an artist to, explicitly say or explicitly, put in writing that they have waived the rights to a particular work. So essentially, unless you can determine that the copyright term to a work has expired in a particular country, you could basically be operating under the assumption that the work is not in the public domain. Okay, I have another quiz. You want to reproduce a sculpture installed in a local park. Do you need permission? A, you can freely use it. It's in the public domain. B, depends on the year of publication and death date of the artist. And C, depends on the location of the work, public or private space. So give it a shot. Okay, this is a tricky one. It's B. It depends on the year of publication and death date of the artist because it depends whether the copyright term has expired or not. One of the biggest misconceptions about the term public domain is that it has to do with whether the work is publicly on view or publicly accessible. Just because a work is in public does not mean that it's in the public domain. And it really only has to do whether the copyright term has expired or not. And kind of the 21st century analogy of this is just because a work is available to view online or because you can download an image of an artwork off of a website doesn't mean that it's in the public domain. It doesn't mean that someone has the right to exploit the copyright of that work for their own intentions. It has to be, if it's copyright protected, you have to get permission to reproduce the work regardless of where that work is. So another exception, fair use. And fair use is a really just kind of as a preamble, fair use is a really nuanced topic. I'm touching very briefly on this as I go through this presentation. We could do a whole nother webinar about fair use. But essentially within the US, fair use is a doctrine that promotes the freedom of expression by allowing a fair use defense when using works without copyright permission from the copyright holder under certain circumstances. And the Copyright Act basically provides that under certain circumstances that promote free speech, uses that are purely non-commercial, like criticism, comment, news reporting, research, may qualify as fair use, and one may be able to use a fair use defense to defend their use of a work without copyright permission. The important thing to note about fair use, especially to keep in mind as an artist, is that it's incredibly context and case specific. We can't say, oh, all of these types of uses are categorically fair use. For each individual use of a work, you have to look at all of the factors and all of the aspects of the particular context of that use and of that work before one can determine whether something is fair use. And as an artist, something to keep in mind is that fair use is a defense to be used by folks who are using works without copyright permission. So you don't have to be in a position to say, if someone says, can I use your work? I think this is fair use. The onus is on them for, if they believe it is fair use, for them to be able to use it without having to consult you in the first place. You don't need to affirmatively let someone know that something is fair use if you're not sure. The onus is on them to use a fair use defense in the case that someone calls them out on it. But like I said, it's broad, it's vague, it's context and case specific. So it's honestly, it's something that's tricky and that trips a lot of folks up. But I think just like what's important to keep in mind is how nebulous of a concept it is. I know it's not very satisfying, but that's our take on fair use. So, okay, another quiz. Which one of the following might be considered fair use? I should honestly rephrase this as which of the following is most likely to be considered fair use? Because, like we said, we would have to know all the details about the work being used, the particular way it's being used. Is it infringing on the market value of that original work for the copyright holder to potentially license it? But give this one a shot. Okay, you guys are killing it. C, illustrative use in an exhibition review in a newspaper. Like we said, this is might. Obviously, we wouldn't be able to make like a definitive, conclusion without knowing all the details. But to kind of go case by case here, cover of a textbook. If something's being used on the cover of something that's being sold, presumably that's being bought by, by schools and other institutions, probably not likely to be considered fair use. Advertisement inside a magazine, probably least likely because, if it's an advertisement, even if it's within a magazine, if it's within a nonprofit educational magazine, right? Just because something's within an educational context doesn't necessarily mean it's fair use. Someone's advertising their services that they have, a financial stake in. It's probably not likely that they would be able to use copyrighted works to advertise their own services or their own interests without licensing that work. Illustrative use in an exhibition review in a newspaper. This is a case where one could potentially make, the fair use defense that not being able to use images of a work within a critical context, like an exhibition review, that is, in a nonprofit journal, one can make the argument that that's potentially infringing upon their freedom of expression. So out of the three, probably most likely to be considered fair use, if at all. Okay, licensing. Let's jump in. So what is a license? I mean, a license is permission. A license is basically an agreement that one party is granting another party permission to do something. In our case, we as licensors, or an artist as licensor, as the holder of copyrighted material, is granting the licensee, the person who wants to use that material, permission to use one of licensor's exclusive rights, such as the right to make a reproduction of that work. And here I've kind of put all the different areas that we in particular do art licensing in, just to give you a sense of kind of all the different types of things that you could potentially be putting agreements in place for. Including uses that are non-commercial. You can still license in a non-commercial context because you want to be very clear about what types of uses of your work you are permitting. And license agreements. I love these little icons from PowerPoint because I have my handshake icon and I have my pen icon. So I'm going to be showing kind of some really brief excerpts from some contracts that we've seen. And I put these icons because if you, especially if you've been working as an artist for some time, you know that so many agreements historically are done, with handshake agreements. And what is amazing is when folks have, a community of trusted supporters or trusted peers that they feel that they're able to enter into those types of agreements with and have complete faith in them. We are obviously in the business of putting everything on pen and paper, putting everything on Microsoft Word, I should say, and having things in writing. Because of course, as an artist, You want to be able to have recourse in the case that something goes wrong. And you also want to have clear expectations about what it is that you are okay with, what it is the client is going to do with your work. And I think that many artists, anecdotally from our work, many artists get nervous about asking folks that they, who might have a stake in their career to kind of enter into more formal agreements for the use of their works. And it can feel kind of scary to ask someone to say, actually, I want you to go through a sort of protocol and to do this in a more official way. But we find that it really kind of strengthens the trust that you are able to have with those folks. And, as an artist, artists are so frequently taken advantage of. I'm sure you all kind of can think of examples of times that that's happened to you. And so really getting things in writing and making sure you have a clear record of what's permitted is so important. One question before I jump in that we often get is like, how do you even know what to charge for the use of your work? That's a really hard question because like I said, there's not necessarily like comparable facts and figures out there for determining a royalty or a licensing fee. The things that we're thinking about when we're kind of generating, estimates for licensing fees for our artists, in addition to like looking at industry standards and seeing, what clients will, be able to meet and what is both fair to our artists, but that clients will still be able to, promote artists' work, is really kind of the natures of the specific use. Like if it's a textbook, how many, or a book in general, what's the print run going to be? Is it going to be distributed worldwide or just in a particular country? Is it going to be sold? If so, what's the retail price? I mean, think about, a textbook that's going to be sold at mass market worldwide distribution, 1 million copies versus like a self-printed zine with 50 copies that's going to be sold just in the US. Those would probably be very, very, very different fees. And also, what's the context? Is this is this BMW coming to put a work in the back on a billboard ad? Or is this an editorial scholarly use where, the fee is going to be really nominal, if at all? It's all about kind of the context of, what maybe a client particularly has to gain from the use of your work. Okay, and as I jump into these license agreements, I just wanted to pull out kind of some terminology that is really good to be aware of, maybe as you're presented with contracts, as you're looking at these types of agreements, to understand what someone is asking of you and what maybe you feel comfortable agreeing with. And I have these terms in red, not because like if someone, sends you a request for an exclusive license, you should block them from your inbox because how dare they? It's more that these terms in red are just kind of broader grants of rights. And so, if you're seeing something that someone is asking for an exclusive sublicensable license, it's something to kind of have your ears perk up and say, they're asking for a lot. Maybe I need to pump the brakes for a second and think about whether I actually want to commit to this. So in terms of scope, you can have exclusive and non-exclusive agreements. Exclusive meaning that if you're granting a certain right to one party, you can't then go and grant it to any other party. So it makes you really locked in to that relationship with that particular client for whatever term of the license it is. So if you're granting someone permission to reproduce, exclusive permission to make a t-shirt featuring a work of yours, you can't grant permission to any other party to do that during that license term. Non-exclusive, on the other hand, obviously gives you a lot more flexibility. You're not locked in. You would be able to grant permission for the same rights to any other person. Control. So sub-licensable means that not only are you granting permission to, say, client A to reproduce a certain work, you're granting client A to grant permission to, say, client B, C, D, E, and so on, as many as they would like, those same rights. So there's certainly a loss of control that comes with a sublicensable license, because you're not necessarily going to be notified or be able to monitor or to be able to have a say in the licensing activities that first licensee is going to be engaging on your behalf. Versus a non-transferable license means I'm granting permission to you, client A, to do something, and you can't then go and grant permission to anyone else. Duration. This is pretty straightforward. Perpetual in perpetuity. means forever. And sometimes it might even say perpetual irrevocable, meaning you can't take it back, versus a limited term, meaning you're saying, let's start out with a 1-year license term, for example, and we'll circle back then and then think about whether we want to extend. And, just to know, obviously there's probably some, industries or licenses where asking for an exclusive sublicensable rights in perpetuity is pretty standard, and someone would not be like, going totally off the tracks by asking you for that. But it's just something to keep in mind, to kind of have in the back of your mind as if you're presented with these types of contracts, to really just like understand what someone's asking you for. Like the more tools you have in your arsenal to understand what the options are that are open to you, kind of the better you're able to navigate those situations. Okay, I'll give everyone a second to read this publishing contract sample. If you've ever had your work published in like a scholarly journal or by like a university press, you've probably gotten a permission request letter like this from a scholar or whoever's coordinating the permissions, so that they can show this release that you've signed to their publisher to show that you've granted permission. So take a second to read. And think about if there's anything here that, based on what we just looked at, seems like maybe something that, a little light bulb would go off and say, oh, hold up, I want to think about this. Okay. In all additions, revisions, and derivations of the work in all media by any means, method, or device, da 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 da, and in advertising, promotion thereof in all languages throughout the world. Wow, that's a very broad grant of rights. To give you an example of like what this might look like if you were to sign off on this, and this is an incredibly hyperbolic example. Imagine that someone is coming to you saying they have a self-published book, they want to put your artwork on the cover, and they're making 50 copies. And you say, yes, great, and I'll sign off to a fee of $25 for that cover use, for example. Imagine that book explodes overnight, it's picked up by another publisher, it's published worldwide, there's a million print run, it's the next Harry Potter, et cetera, et cetera. You would have already granted permission for all of those future editions, all of those, say, ebook copies, all of those different language editions, and all advertising and promotional uses. That's a lot more than maybe you were originally anticipating. And had you limited the scope of what you were granting permission for, then they would have to come back to you and say, oh, we're actually printing a million more copies. And you would be in a position to say, well, okay, well, then I want to negotiate my fee and I want to negotiate the terms. Okay, media contract sample. This is like for film and television use. So take a second to read. This one's a little bit shorter, and then I'll show you what I've highlighted. Okie doke. Licensor hereby grants to licensee a non-exclusive license to include the material in whole or in part, edited or otherwise modified in licensee's sole discretion. Whoa, whoa. So that would mean, say, if you had like maybe a film of a performance you did, you would be granting permission for them to chop it up and recut it however they would like, without showing you the final cut for your approval. So that might be something where you want to say, actually, I want to, it has to be shown, without any modification, without any cropping, without any manipulation, or you might just want to say, I have final say over the final cut, and you have to send that to me for me to approve. And down here, in other promotional material, as those programs are distributed worldwide in all media known and hereafter devised in any and all languages, on-air promotion and advertising related thereto in perpetuity. So again, this is a super hyperbolic example, but imagine you grant permission for your a work of art to be used as set dressing that's going to be in just like a couple frames of a movie, and you sign off on this for a fee for those frames. Imagine then the studio decides that a still image from one of those frames is going to be the promotional hero image. It's going to be on billboards. It's going to be the poster at the movie theater. I don't even know, they're going to make a t-shirt with it. That's a case where maybe you would have wanted to have been notified and you would have wanted the opportunity to push for a higher fee, given that your work is not just being used as set dressing, but it's being used to promote the film, which could be, generating who knows how much in ticket sales. Museum contract sample. Okay, this one has like some little check boxes. And while you read, well, I'll give you a moment to read before I jump in, actually. And if I'm going too fast on these and you want more time to read, just let me know in the chat and I, I'm in no rush. So, okie doke. So if you have ever had your work um, on loan to a museum or like other, institution that's presenting exhibitions, and that your work will be on view at, or if you've had your work acquired by a museum, first of all, congratulations. And second of all, you've probably gotten, some sort of paperwork associated with it that may include either language pertaining to not a non-exclusive licensing rights or just a separate agreement, a non-exclusive licensing agreement. We call these NELs. Um, these museums are often going to ask for a pretty broad grant of rights in these NELs, not because they are doing something wrong, but because of course they're going to ask for what is favorable to them to be able to do, which is use the work how they would like to be able to use it for their own purposes without necessarily having to interface with you or pay you for additional rights. It's not to say, not to demonize these museums for asking for this very broad grant of rights. It's just to note that this is what, they're of course going to ask for because it's going to make their lives easier, and that they're probably anticipating that you as the artist might say, actually, I kind of want to cut down on this a little bit, and I want to limit a little bit more what I'm going to be allowing you to do without consulting me on or without paying me for. And some artists also, like here we have some check boxes, like sometimes on, the loan agreement itself, there'll be like check boxes, what are you okay with? And I know some artists, especially if you're like an early career artist, or maybe if you're not in like a point of complete stability in your career, maybe it's like your first time that your work is going to be on view at a museum. It can feel really scary to push back against these museums because, we have artists who say, well, I don't want to say no, and then they say, well, we're not going to show your work anymore. I can say anecdotally that we have, worked with so many artists who have limited the rights that they're going to grant to museums and instead just said, you have to come to me on a case-by-case basis for permission on these uses. And I've never had a situation where the museum was pulling out, or there was any sort of backlash to the artist for those uses. They understand and they respect that artists have their own, will of course have an interest in understanding how their work is being used, despite what they ask for. So feel empowered to kind of be able to push back on these and to be able to make your voice heard. So here what they're asking for: scholastic scholarly research, online research databases, material educational guides, editorial content, et cetera, exhibition catalogs, teaching materials, educational films, annual reports, announcements, promotional advertising and publicity. I'm skipping over things. Commercial use, including postcards, posters, and other objects, and other usage consistent with their programs and missions. This is a lot, and this is including commercial uses that are no longer necessarily connected to maybe a particular exhibition or the work being on view itself. Like these are uses like annual reports, advertising, commercial uses that obviously are both, potentially generating revenue. And you as an artist might, not have as many sources to generate that type of revenue as the museum does, but also, might be for purposes that, like we said, are not directly supporting that particular exhibition that you've signed on for. And of course, if your work is being reproduced on a postcard, on a poster, on a tote bag, you probably want to see what it's going to look like. You want to make sure it's not cropped. You want to feel comfortable with the quality of the reproduction. Were you to check these boxes, you would essentially waive the ability to review these types of uses, to say yes or no, and to collect fees. And then at the bottom, additional works. Basically, what this says is that if you were to check this box, then any other works that the museum acquires in future by you, these same terms would apply. So it really locks you in, not just for this particular work, but any future works that the museum acquires. So it's just kind of a reminder to be, to be cognizant, to read things thoroughly, and make sure you understand, what you're saying yes to, if you're saying yes to something. Okie doke. Copyright 102. I'm going to do sort of like a hopscotch on a few different topics here that are of interest to me and that are kind of more focused on copyright and artist rights at large internationally, to kind of give you a sense of what's going on in other countries and hopefully maybe what could be going on in the US soon. So reprographic rights. If you've never heard this word before in your life, do not worry. Neither had I before I started working at ARS. What we handle at ARS, and what if you've ever done licensing on your own, what you've been licensing is probably primary rights, such as the right of reproduction. For example, licensing the rights to reproduce a work by Helen Frankenthaler on the cover of a book. That's a primary right. However, reprographic rights refers to the reproductions of reproductions. So for example, if someone were to take that book and scan it and digitize it, or make a photocopy of it, or fax a copy of it, those are reproductions of a reproduction. So there's like the original work, the reproduction of the original work, and then the reproduction of that reproduction. That kind of step 2 is that's reprography. And from the point of view of the rights holders, these are considered secondary rights, and in the US, they're generally considered fair use. However, this is not necessarily the case in other countries. There are collectively, these rights, reprographic rights and other secondary rights, are collectively managed in other countries that have an infrastructure set up for extended collective licensing, such as, a lot of countries in Europe have these structures, like really strong reprographic rights infrastructures, meaning that artists whose work is reproduced in, say, books or reproduced online in those countries can make a claim to receive compensation from the government that is theoretically awarding them funds for the times that their work was reprographically reproduced, meaning that reproductions of their work were reproduced. I know I'm using the word reproduced about 14 times per sentence because there's no really good synonym for it in the realm of copyright. And what I mean by collective management is that folks are not seeking, prior approval on these uses from the copyright holder before doing them. I mean, imagine a system where every time you wanted to, say, scan pages in a book, you had to seek permission, not just from like the copyright holder of the author, but of every single image in that book. That would be crazy, and no copyright management organization could probably handle it at this time without like way more advanced technology. So while anyone can do that without having to seek permission, there's still basically money that is available, that the government, through taxes and other forms, that is going to remunerate artists for basically their contribution to the culture at large in a greater sense. So as an ARS member, not to plug our membership program, but you are eligible to make claims in those countries if your work is available internationally, and a lot of, say, textbooks that are available internationally or course packets that are available internationally, you might be eligible for reprographic claims from those countries because they might have calculated that you are eligible for that via their algorithms that determine reprographic rights remunerations. They might have already determined that you're eligible to receive money, which is pretty amazing because lots of artists join and they're like, wait, what did I get paid for? I didn't even license anything this year. And it's coming from other countries because they have the system already set up, which is cool. We would love to have this in the US sometime in the future. Obviously, programs that pay artists are great. Resale rights. So if you are an artist who lives in the US and your work has ever sold at auction in the US, or it's been resold in the US, you know that you probably didn't see any money from that, which really sucks. This is not the case internationally. Many countries, in particular these countries in red on this map, have what's called an artist resale right. It's also called droit de suite in Europe, forgive my French pronunciation. Um, and what this is, it's basically a form of residual payments for artists, where every time their work is resold, whether by an auction house, by an individual seller, they're required to report and pay a percentage of that sales price to the artist. Um, and this applies, as long as copyright protection is granted. So even heirs of artists can continue to receive these resale royalties. This is something that we at ARS have kind of been lobbying for some time. We have a little petition on our website. You can go on our website and learn more, see the bill that we've supported, which is called the Art Act. There's also the European Visual Artists, EVA, has a great resale right campaign website. I think I put the link here, but it's really obviously a shame that all of the, if you think about all the speculators and flippers who are, able to accrue all of the wealth of these secondary sales without artists who created those works being able to see any of it in the US is, of course, hugely disappointing. And the US Copyright Office. Like I said, I'm just touching really briefly on this. Some artists do choose to register their works with the US Copyright Office. Like I said, it's not necessary. Your work is protected regardless. You do get some benefits from registering the works, especially if you are planning to sue someone. There's other types of monetary damages that you can seek if your work is registered with the US Copyright Office. That being said, it takes time and money to register your work. So it's a cost-benefit analysis for you as an artist, whether you think it's something that is that's going to be necessary for you, or maybe you just want to register certain works or over a long period of time. You can rest at ease knowing that they're protected regardless. One benefit that you do get from registering is also being able to take advantage of the Copyright Claims Board. So this is a very recent development in US copyright law. A few years ago, the Copyright Office established what's called the CCB, which is basically Small Claims Court for copyright infringements. And it's meant to be like a more accessible form of handling copyright disputes than filing something in federal court. And it's also meant to be, accessible to artists so that they might be able to navigate that system without hiring a lawyer. That being said, this is still really new. It was only, the law was passed in 2020. I think it was established in 2021. So there's not really a lot of data about these cases yet. And we have been noticing that still many artists who are using the CCB system are still hiring lawyers. So the extent to which it's actually, something that artists are navigating on their own, maybe not completely there, but it's certainly an improvement. And it's certainly, if you have, claims that are less than $30 that are more nominal, might be a great option for you. I would really recommend checking out the Copyright Alliance. They have a lot of amazing resources regarding copyright, but also about the CCB. For visual artists, I really highly recommend giving their website a look, and they have a fabulous blog, as well as our blog as well. So definitely lots of amazing resources to check out there. And I would be remiss if I didn't say that our membership is open to any artist. Membership is free. There's no annual dues. If you would like to become a member, you can check out our website. We have our agreements there, so you can see all the terms of memberships there, laid out for you to see. And of course, feel free to shoot me an email if you have any questions. I would be happy to talk more about our work, about membership, et cetera, et cetera. And thank you all so much for joining, and I'm happy to answer any questions. Thank you again, Sapira, for having me.
Thank you for all of that information. That was very, very helpful. And I didn't know most of it. So that was really, really cool. It was definitely a learning experience for everyone. So if you have any questions, feel free to raise your hand or type it into the Q&A. We can wait a little bit. I don't see any hands up.
I hope it's good if people have no questions. It means
Yeah,
I
it was
answered everything.
everything was answered. So if there are no questions, thank you so much for all of the information. Thank you, audience, for attending. And if you do have any questions, maybe we can share your email.
Oh,
for us.
wait, a question just, I will share my email, but I see someone just put in a question.
Oh, okay.
Do reprographic rights pertain to photos of public art? If I, as a photographer, create an image of a cityscape, am I infringing on muralist copyrights? I think you might be referring to reproduction rights. So in terms of like making a reproduction, or okay, I think if you're understanding, like if I take a photo of a work, is that copyright infringement? It depends on how you use that work. So I mean, if you are taking a photo of a work, um, and you are then, it has someone else's copyrighted works in it, and you are using that for commercial purposes, like you're putting it on a print and then you're selling that print, and you didn't get permission from the rights holder of that original artwork. Like I said, I'm not an attorney, but I would say that that would probably be copyright infringement. So using that for your own purposes when there's other rights pertaining to that photograph, definitely something to be careful of. And I'll put my email at.
Oh, I think that was sent to me instead of,
Oh, shoot. Okay, I'll send
sorry.
it. I always do this in every Zoom chat. I always.
Awesome. Again, thank you so much. That's awesome. Thank you so much for being here. That was really, really wonderful. Stefan, did you have anything else you wanted to share? Stefan's my
No,
coworker.
I think there's one more question in there. Did you answer the bad contracts question?
Mm,
Um, I mean,
And
I'm not. I don't think we'd be in a position. I'm sorry that you have seen bad contracts, but I don't think that. I mean, if there are already contracts that you're already engaged in, we're not going to be in a position to be able to help there, unfortunately. But hopefully now in future, if someone sends something to you, then you can say, I don't want to sign this if you don't feel comfortable with it.
so it's not signed.
hey, Sapira, can I just ask one more question? Not to belabor the point. And Kara, you mentioned it a little bit at the beginning of the talk. Because we're at the cusp of AI,
Yeah.
and right as we're moving forward, and I don't know if there's like anything that you want to speak about, or if there's anything interesting
Yeah.
on the horizon that's coming up with AI and copyright.
For sure. We actually have a portion on our website. Like let me see if I can find the link, because we have an AI updates website where we are basically, we're also involved not just in licensing, but lobbying for artist rights at large. And so we have a number of kind of bills or like legislation that we've signed on to and endorsed. So I can put the link in the chat, because there's definitely a lot of cool efforts that are going forward that are going to be important for artists to be aware of. I can say that, what I can share now is that we have engaged outside counsel to kind of explore our options as regards our own members. So it's something that we are thinking about very actively, especially as regards the use of artists' work in data sets that are then generating outputs. So definitely something to be aware of. There's so many facets to this that are developing. Most recently, I think something that's been that we've supported is the let me just find the title of it, is the Generative AI Copyright Disclosure Act, which is basically would make sure that any outputs are, basically in some way disclaimed that they are AI generated, and hopefully to to prevent from those works kind of flooding the market and taking up space where otherwise folks would be seeking to compensate actual working artists. Oh, another amazing resource to check out is Fairly Trained. And we just actually recently did an event with them, and they are a company that certifies AI companies that are actively licensing their work with artists. So they're actually, seeking permission from creators and paying creators to use their work in data sets. So there's certainly a precedence for AI companies fairly licensing their trading data. That's obviously what, we would want those AI companies to do. So hope is not lost. It's not too late. And so we're all staying tuned.
Very cool. Very
And I
cool.
put our AI updates
Yeah,
link.
and I think there's one more question there, Sapira, from Melody.
Yeah.
What
What is
is
your
your opinion
yeah,
if
go ahead.
someone doesn't want to show you a contract beforehand? In terms of before you're doing something, I mean, I would say don't do anything unless you're signed it. So I would say if you you want to know what you're getting into. So I mean, if someone doesn't want to show you a contract, like I said, I'm not an attorney, but I think as any person would want to know what the expectations of them are before you're doing something.
Yeah, that definitely feels like a red flag.
Yeah.
It does.
Okay. Are there any more questions? Last call for questions. Mhm. Okay, I think more. Okay, we're good. All right, thank you everyone, and thank you, Kara. You've been so amazing. This
Thanks
is
for
really,
having
really
me.
valuable, not just for Nevada artists, but also for a lot of people. Thank you, and I hope you all have a wonderful afternoon.
Thanks so much for having me.
Thank you.
Bye.